Hello, everyone, and welcome to One Civil Law, and I hope you're having a great day. For today's story, we turn our attention to a recent decision by a Pennsylvania state court in response to a public school arguing that a person didn't have a right to know what the school was teaching because it's a secret. Okay? So you can't know about what the school is teaching the kids because it's a secret. So we don't have to tell you. That's exciting information. And the Pennsylvania court had a bit of a problem with that. And so we're going to review this decision because I thought that was pretty exciting. We turn our attention to this decision in the matter of Anne Trethaway, the applicant, versus the Dowlington Area School District, decided February 25th of 2025. And we read the facts as follows. The background is thus. On January 3rd of 2023, the requester, a person, submitted a request to the school, an open records request for the following records. This is what the person would like to know from the school, the government. Hey, government, please give me these documents. Copies of all documents and materials and all presentation used by DEI program director and DEI staff that were used to instruct or lead any training or program to any staff, teacher, counselor, or student. Copy of any copyright information on material used, and copy of all documents and material and all presentations that were used to instruct or lead any cultural awareness, courageous conversation, unconscious bias, and cultural proficiency training or programs to any staff, teacher, counselor, or student. As per district policy, a fee may be charged, which is pretty typical in an open record request. It's like, okay, so we've got the school and we think you're doing some DEI. And so basically, long story short, I want a copy of all the materials you use to train the teachers and also all the materials that you use to teach the students relating to DEI. That's what I would like. I'd like all those materials, please, so I can know more about the things that you're teaching the kids. Could I please have that? I'd like that information, please, government. Could I have it? All right, on January 5th of 2023, the school district denied. They're like, no, you can't have the material. For what I thought was a pretty creative reason. I have to give credit to their lawyers, I guess, on one level. This is creative. They said, your open records request is denied. The relevant law exempts from disclosure a record that contains or reveals a trade secret. It's a trade secret, man. It's like the formula for Coca-Cola. Now, incidentally, by the way, for the purpose of discussion, one of the things that trade secrets have to be is like kept secret. And that's, one of the major things about the trade secrets. So I'm not really sure that you can have a trade secret, maybe amongst your own staff, maybe. But once you start teaching it to the kids, they're not part of your staff. So I'm not really sure how you're maintaining trade secret protection at that point. But that's what they want to go with. We're teaching the trades, keeping the trade secrets from you, even though we're teaching it to the kids, which is an interesting posture, to say the least. Or it's confidential proprietary information. Confidential proprietary information is defined as commercial or financial information received by an agency, which this isn't because it hasn't been received, right? This is what they're producing. So that doesn't really make sense. The request in this paragraph is a trade secret and would cause substantial harm to the competitive position of the school. What? What? How? The response included a certification from the school district's DEI director who stated in pertinent part the following. So this is, I suppose, an affidavit, I guess, or a quasi-affidavit. The DEI director says, I create the materials requested above prior to my employment by the school district and prior to my appointment. They were not created using school district resources and are protected by copyright. Okay, so they weren't created by the government, but I'm still using them as part of the government. So but I'm the director. So I've received my own materials. That's an interesting one. I've received my own materials by going from the private to public capacity. Okay, that's what they're going with anyway. These materials are not made available to the public or other organizations, as that would substantially interfere with the confidential commercial nature of them. Again, we're teaching the kids how confidential can it be. And I ensure the confidentiality of these materials using best practices. They're password protected and the credentials are maintained confidence. No person outside the school district is provided with or permitted to observe these materials. We were doing pretty good on number one. Number two, I'm not sure. Trade secrets also have to be somewhat closely held. You can't just tell everyone in the company. So that's one of the reasons, for example, that like Coca-Cola, like at least legendarily, like only like 2 employees know the recipe, and they travel on different planes and so forth, and they keep the recipe in a vault and so forth and so on, right? They have to be kind of closely held. So it's like, oh, I only told everyone in the school district. Again, not really sure I'm feeling the trade secret protection over here, but okay. The school district employees are notified the training is confidential. And to the extent the training is interactive, that would be with the students. The school district's employees are assured their participation would not be released or otherwise disclosed. Well, that definitely satisfied me from a trade secret protection. That's great. So even though we're literally teaching the students, their trainings are not going to be disclosed because I've given them assurances. I mean, what's to prevent the student from just telling anyone? I don't know. But I mean, this is some bizarro world trade secret analysis. I'll tell you what, man. This is bizarro world trade secret analysis. School district employees understand their answers will be kept confidential from the public, are only disclosed to select school district employees to the extent necessary to evaluate training. Disclosures of the material will put me and the school to marketing disadvantage. Again, you're the government. You would put the government at a marketing disadvantage? Okay. Not available to the public or competing services as there's no similar from any other district says to this one. We're a special district. We're a special public district. Okay. Amazingly enough, the requester is not buying this and decides to appeal to some sort of board. And they state their position relating to all this about, the secrecy and all the rest of it and all those things. So whatever board they appealed to also said no. It found the affidavits established the requested records constitutes trade secrets and confidential proprietary information. Its reasoning is as follows. This should be good. If the materials were made public, this would place Brown, the person, and the school district, the government, at a market disadvantage because this training program is unique. It's a really special DEI training. No one else has DEI training like ours. We have the bestest DEI training, don't you know? And if other people learned of our secret, man, people wouldn't come to our school. But you're a public school, so I guess people wouldn't move to our town. So if the secret training got out, people wouldn't come to our town anymore because it wouldn't be unique. They're coming to our town for the secret training. That must be it. Okay, that's a weird position, but sure, let's go with that. Although the materials are shared with school district employees, they establish safeguards to prevent their unintentional disclosure to persons outside the school district. Again, not sure how you're doing that when you're teaching the students. And then whatever board said, I'm not feeling it. I'm the trade secret though. All right, so then we appealed. we appealed from whatever random board and we appealed to a trial court. So it's like, okay, I've gone through my administrative procedures and I'd like to now go to court to force you. All right, so let's try the trial court. The trial court says no. The trial court's like, nope, this is fine. This is all good. It concluded that Brown's certification and supplemental statement established the training materials were in the possession of the school district, were confidential, and had independent economic value to Brown. Their disclosure would harm Brown's competitive position in the education industry. Even though she's teaching that material to other people in the school district who now have that information and could teach others and stuff. Again, the close held nature of the trade secret leaves a lot to be desired from trade secret law. Just saying, one of the key features of trade secrets is actually keeping it secret. And the amount of people you're disclosing the secret to is not encouraging. How do you keep a secret among 3 people? You kill 2 of them. Right? That kind of thing. So it's like, this is fun and exciting. Anyways, so now we're going to go off to the Court of Appeals and see if the Court of Appeals would like to have a word about this issue. So let's try the appellate court and see what they say. On appeal, the requester argues the trial court erred in holding that the DEI materials fell within the exemption for trade secret. Because Brown, the school district employee, shared these materials with the school district in the scope of employment, they're not secret. I mean, yeah. Further, the language of the affidavit is too general and too conclusory to establish an exemption. Yeah, this is making the IP lawyer in me grin. Trade secret law is normally thought of as being within the IP law umbrella. So this is sort of in my domain. And I'm like, this is a very interesting trade secret. Yeah, we told a whole lot of people about it, man. I'm not sure it was exactly need to know, man. Woof. All right, so what is the applicable law in Pennsylvania? The applicable law provides their open records request law provides that unless otherwise provided by law, a public record shall be available for inspection and duplication in accordance with law. All right, public records should be public. Well, wow. The relevant law specifically provides a record that constitutes or reveals a trade secret may not be disclosed or doesn't have to be disclosed. The relevant law defines trade secret as information, including a formula, drawing, pattern, compilation, including customer list, program, device, method, or technique that process that derives economic value, actual or potential, from not being generally known and not being readily ascertainable by proper means by other persons who can obtain the economic value from its disclosure. In other words, keep the secret though, is subject to efforts that are reasonable under the circumstances. This term includes data processing software obtained by an agency. Okay, fine. Establishes the relevant law employs the definition of trade secret found in the Uniform Trade Secret Act. I mean, that sounds very familiar to me. I understand this language. Like, yeah, that's basically a trade secret. You keep it secret. You don't tell people. You keep it close hold. You keep it basically need to know. You don't tell anyone who needs to know. You try to keep it as little as possible, and you protect it from the general disclosure. That's what a trade secret is. These people are not doing the trade secret thing. They're not doing a really great job. And also the fact that what we're teaching your kids is a trade secret is a whole nother thing. This would be roughly akin to if Coca-Cola during their tour said, okay, you're part of our tour now, and so we're going to tell you the secret of the formula of Coca-Cola, and then told them. And then Coca-Cola's like, it's still a trade secret because they paid a fee. I think it's free to go to the Coca-Cola tour, but let's pretend. They paid a fee to be part of our thing. And so we could tell them because it's trade secret. We tell people every single day, but it's still a secret. I don't know, man. I'm not really feeling that secrecy bad. I have a lot of problems with that. Case law relevant under the relevant law has established the following factors to determine whether or not it's a trade secret. The extent to which the information known is outside the business. In other words, if it's not a secret, it's not a secret. The extent to which the information is known by employees and others in the business. In other words, keep it close hold. The extent of the measures taken to guard the secrecy. How are you doing in trying to keep the secret? What measures do you take? Do you lock it in a vault? Do you not tell anyone? The value of the information, the business and its competitors, the amount of effort or money expended in developing it, and the ease or difficulty with which the information could be properly acquired or duplicated by others. In other words, if it's really simple, probably not much of a secret either. A trade secret requires substantial secrecy and competitive value. I mean, this is basic shit. The relevant law defines confidential propriety information as commercial or financial information received by an agency, which again, in this context is really weird because it's the director of DEI who developed it. Now, they developed it outside when they weren't an employee. But again, it's like they're the director. So they received it themselves. Isn't that sort of self-dealing at that point? They received their own information by taking off their private hat and putting on their public hat. And now they've changed from one hand to the other. It's like, that's a very weird definition of receiving when I receive it from myself. But okay. In any event, which is the relevant confidential propriety information is privileged or confidential, and disclosure of which would do substantial harm to the competitive position. Critical of the confidential inquiry is what efforts could be made to keep the information confidential. And again, actually keep the secret secret. To determine substantial harm of competitive position, the agency must show the existence of an actual competition in the relevant market, likelihood of success that the information was released. Competitive harm focuses on the use of the proprietary information by the competitors. So, Pepsi can't just steal the information and then make Coca-Cola. They can develop themselves if they can reverse engineering it. Reverse engineering is legal. So if they can reverse engineer it, that's fine. And then they can make Coca-Cola themselves. Now, they probably wouldn't want to, because at that point, there's nothing differentiating their product from Coca-Cola. And so why would you do that? But they can. But if they just steal the information from Coca-Cola, they can't do that. Incidentally, there was a somewhat famous case where this kind of happened, but didn't, because I forget which way it was. I think it was someone trying to take information from Coca-Cola and give it to Pepsi, but it might have been the other way around, which way it was. But there was basically someone who worked in the lab, right? There was a lab tech or someone like that. And I think they might have been mid-level or if not even higher. But there was some sort of lab tech, and Coca-Cola or Pepsi, as the case may be, was trying to develop some new product, which of course, they're doing all the time. And, they basically picked up the phone and they called the competitors hi, I'm the lab tech from Coca-Cola. Hey, Pepsi, would you like the super secret thing? I can provide you the formula, and I can provide you some product samples, and I can provide you the preliminary labels and stuff. I can provide you all this stuff. And then Pepsi called the FBI. And, that was sort of the end of that game. Then the FBI met with them and said, hi, I'm an employee from Pepsi. I would like to buy your secret. Would you like to sell me a secret? I sure would. And the person went to prison. So that was super exciting. And obviously you can't do that. So but that was a pretty famous case. In any event, exception to disclosure of public records must be narrowly construed because we want the public to be public. The party asserting the exemption bears the burden of proving the record is exempt from a preponderance of evidence. The agency may present evidence on its claim for an exemption by affidavit or assertion. Absent evidence of bad faith, the veracity of the evidence should not be questioned. The veracity of the affidavits should not be questioned. However, conclusory affidavits do not suffice. Stated otherwise, an affidavit that merely tracks the language of the exemption will not establish a request. So you can't just say it's true, right? You can't just say this is trade secret in your affidavit. You have to establish why it's a trade secret, right? So we'll take what you say is true. But you have to actually establish the legal exemption. Batman's Pet Goldfish for $5 says, wait, wouldn't a teacher taking this info to make a program in another school violate trade secret law under this argument? Presumably it would. Which is another reason that it's a real problem, because the more teachers you teach, the easier it is for it to escape the lab, as it were, right? So the more people you tell the secret, the harder it is to keep the secret. And the harder it is, of course, to prove that the person stole it, as opposed to just coming up with their own. It just happens to somewhat track it. So yeah, there are many, many problems with that. Good times. All right, trade secret. Requester argues the school district did not meet its burden of establishing the requested records meet the trade secret exemption. The DEI training materials were created by a school district employee, distributed to school district employees, and blessed as official training by the school district. Records related to agency activity are public and must be disclosed, and there's no question that DEI training materials were used in a school district activity, namely the teaching. Further, requester notes in the affidavits Brown previously stated the withheld records are protected by copyright and simultaneously privileged and confidential. Requester argues they cannot be both. Copyright laws do not preserve trade secrets. Rather, copyright materials cannot be used or duplicated without permission of the author. This is the limitation of their protection. Yeah, I mean, that's a very fair point. It's a little hard to have both. Also, you can't do that with a patent. Right? So Coca-Cola could have gotten a patent for its formula, but they're like, let's keep it a secret instead. And so it's and then it gets to be a secret as long as you can hold the secret. But yeah, it's you can't have both. That's a very weird thing to try. It's copyright and a secret at the same time. Wait, what? Requester states she seeks only record created, maintained, and transmitted in the course of Brown's work as a public official. She does not seek records created by Brown in the personal or commercial capacity and used outside the employment. So yeah, I'm not even seeking the base materials. If you want to keep those secret, that's cool. So I'll even spot you that issue. So the materials you handed to yourself I'll spot you. You can keep those secrets. But anything that you then generated from that as a school district employee, you then did in your capacity as a governmental employee. At that point, you're wearing your governmental hat. So you don't have to disclose me the thing that you handed to yourself, but you do have to disclose anything that the government created, which, fair enough. That makes logical sense. Finally, requester argues that Brown's certification and supplemental attestation were inadequate to establish a trade secret. In any event, Brown's full-time employment with the school belies his claim that he's engaged in a trade. Yeah, what exactly is the trade? That's an interesting one. Like, when you're a school district employee, what is your trade for there to be a trade secret of? Right? It's like, what is the trade? School district employee? That's your trade? So it's the government creating secrets for itself. It's okay, but that seems to be what public law is trying to get at. He's not allowed to do that, man. Yeah, Brown affidavits state that no person outside the school district is provided with or permitted to observe these materials. Information shared with an untold number of school district employees cannot be secret. Yeah, the close-held nature of the trade secret leaves a little bit to be desired. For its part, the school district does not address trade secrets in its brief, except in a passing way. The school district focuses on confidential and proprietary nature of the requested materials. Brown's certification established that training materials are not available to the public, and Brown took steps to limit their production by school district employees. The school district emphasizes the statements in Brown's certification and supplemental attestation are uncontradicted. In any case, the requested training materials are already previously determined to be records that constitute trade secrets or proprietary information. The relevant law protects secrets from government disclosure. The term trade secret and confidential proprietary information are separately defined and thus must be separately analyzed. Fair enough. They're separate terms. Let's give them separate definitions. I buy that. A technical secret may constitute a technical drawing, formula, plan, device, or compilation of information that is used in a business and that gives that individual advantage. A classic trade secret is the Coca-Cola formula, which has been zealously protected for generations against acquisition by any other soda manufacturer. Customer lists used to sell household articles door to door, a fudge recipe, and companies' pricing information can constitute trade secrets. A trade secret does not include a worker's aptitude, skill, dexterity, manual, and mental health, and other knowledge the worker obtains in the course of employment. So, no. A patent also is not a trade secret because the word patent literally means open. So it can't be open and a secret at the same time. That would be hard. The patent allows the owner licensee to patent information for a fee. However, it enters the public domain and can be used by anyone. It sure can. The same is true for copyrighted work. An applicant applying to a copyright is required to submit the copy to the Library of Congress. This is consistent with the fundamental purpose. It is not to reward the labor of authors. To claim the trade secret exemption from disclosure, the record must have been an actual secret of peculiar importance to the business. The records must be genuine secrets, not tricks of the trade. Central to a trade secret is the value derived. Brown stated the requested materials are his own, which they're not. They're the government's because you're a government employee. And it's safeguard to maintain their confidentiality. He created the materials prior to the employment, but that's not what we're looking for. In the supplemental attestation, Brown stated he used the materials outside the classroom as a creator and president of a DAP. Well, then you have a real problem. If you're using the materials outside of your secret role, then it's even harder to maintain a trade secret. It's a trade secret, but also I'm using them in a different context at the same time. That's an interesting trade secret. I don't think these people understand what a secret is. Again, these materials are not distributed as part of the training program. Should a competitor obtain them, his training portal would lose value. These affidavits may establish the training materials have proprietary value to Brown. The DEI training is a competitive industry, and the training materials are protected from duplication. However, These affidavits do not explain how these training materials derive their value from not being generally known and not being generally accessible by proper means. To the contrary, the training materials derive their value from being shared with school district employees and anyone who participates in the training program. It's like, yeah, I mean, the very thing is, it's like, how do these materials gain value by being secret? They don't. It's training material. The only way it gains value is by being used to teach teachers and then teach the students, which again goes to the contrary. Again, Coca-Cola really does not want you to know their secret. They don't want people to know what it is. They don't want to tell people. They don't want to teach people. They don't want to teach their employees, and they definitely don't want to teach the public. They would like to keep it as close hold as they possibly can and still make the thing. They still make the thing, right? So it's like, yeah, but you said, okay, this is training material. So this would be equivalent, again, to Coca-Cola being like, okay, we're going to teach all of our employees how to make the super secret formula. Again, I'm not really sure that you understand the assignment at this point, but okay. This point is illustrated by a relevant decision. This case concerns a screenplay which was found to have no economic value until exploited through dissemination. As such, the screenplay is not a secret. Likewise, in Marindi, the federal district court held that copyrighted audiovisual material sold to independent insurance agencies, financial and insurance marketing firms, financial planners, and major insurance companies did not constitute trade secrets. The economic value was derived from the sale of the product. By active marketing, the product became readily ascertainable by proper means by persons who could obtain value from their disclosure and use, and therefore not a secret. Similar to a poem, screenplay, or educational software, the training materials only have value when shared. As such, they aren't a secret. Yeah, I mean, again, it's like, this is not really that hard, man. This is not really that hard. This is fun and exciting. Furthermore, the training materials are not in the nature of a formula, drawing pattern, or compilation, including a customer list, program, device, method, technique, or process. Brown's assertion and supplemental certification conflate the concepts of trade secret and product. A trade secret is essential to a product, but not the product itself. For example, Coca-Cola uses a secret formula to create its product known as Coke. Right? The secret is not the same thing as the product. The product may or may not reveal the secret. And again, backwards engineering is legal. So if you can take the Coca-Cola bottle and you can reverse engineer it, then you're allowed to manufacture Coca-Cola. Now, you can't call it Coca-Cola because that would be trademark infringement, but you can manufacture it. So if you're a competing company and you want to manufacture Coca-Cola, if you can reverse engineer it and you can produce it, you can sell all the Coca-Cola you want. Just don't call it Coca-Cola, call it something else. But you can do it, it's fine. Michelle for $9.99 says, it seems like they're trying to treat training material like it's a teacher's edition of a workbook with all the answers. Yeah, a little bit, Michelle. That's basically what's going on. You got it, ma'am. Confidential proprietary information. Next, requester argues the school district did not establish the requested records could constitute proprietary information. There's no evidence the disclosure of this material would cause Brown substantial competitive harm. Because Brown did not identify his competitors, that's fatal to his claim. It will hurt me because it will hurt me by my competitors gaining value. Who are these competitors? Cricket noises. Particularly within the context of the government, I would like to take note. Brown's complaint of harm in his supplemental attestation contradicts his statement in his certification that materials are not made available to the public or other organization. Requester directs his courts to his decision, naming interpreters providing translation services are protected against disclosure of confidential proprietary information. I mean, fair enough. I mean, fair enough. I don't want to tell you what translators we used. Find your own translators. In that case, the attestation included precise factual details, such as descriptions of the information claimed to be proprietary and difficulty of the acquisition. By this contrast, Brown's certification attestations are conclusory. Again, courts don't like conclusory. The school district responds it met its burden. The Court of Appeals is not feeling it. Its certification and attestation establish there's a competition in the field of DEI training, and the disclosure of Brown's training materials will harm its ability to compete. They need to be kept confidential to protect their use by other schools, districts, and other educational agencies. The school district cites some law. In that case, the requester sought a manual, a copy of the Pennsylvania Higher Education Assistance Agency's employment manual on debt collection procedure. The relevant agency denied the request, and the relevant board affirmed. The manual is maintained strictly within the agency and available only to employees in the loan asset maintenance division. So this is sounding a lot more promising, right? This is sounding a lot more promising, like closely held, right? We didn't teach like literally we didn't basically teach every single teacher in the district, right? We have a debt collection agency, and we only teach the bare minimum number of people those things. This is a lot more promising. This is a lot more promising. All right, each page was marked proprietary and confidential. Further attestation described the type of information contained in the manual for which the agency expended significant effort and cost to develop. Disclosure would allow competitors in the federal student loan guarantee market to learn their collection methodology. In fact, they were in the process of bidding on contracts relating to exactly this issue because people saw value in it. So it's like, I can actually prove the value because of those things, right? So they provided a lot more factual detail, right? They didn't just say, this is trade secret, yo. They said, okay, let me tell you exactly what's going on. We keep it closely held. It's only within the people that are doing debt collection. We mark it confidential. We tell only the people that need to know. And our competitors see value in it and here's our competitors, and they see value in it because we're currently in the process of negotiating contracts relating to that. That's a lot more specifics. That sounds a lot more promising. Finally, the school district again says the records sought by requester are the same records that the OOR has already held to constitute confidentiality. I'm like, well, I'm thrilled the OOR decided that, but I'm a court of appeals, bitch. So guess what's happening now? Right? Oh, this board made a decision. I'm like, that's neat. I'm thrilled for them. That's exciting. Confidential propriety information has a confidential or financial value, is privileged or confidential, and key to the competitive process of the person that gave the information. Confidential requires an effort by the party to maintain secrecy. The burden is on the agency receiving the request to establish the exemption. The court has explained this burden as follows, and then they talk about that a little bit. Examples of confidential propriety information include a company's business methods, production quantities, and list of interpreters able to provide telephone translation services. Again, because we've had specific cases relating to that. Not necessarily that those would be true in every case, incidentally, but it's possible, right? It's possible if you provide enough information. So I don't know that you could necessarily go so far as to say that an interpreter for a phone service is necessarily confidential. I'm not sure you can necessarily extract that from the case. But it's like you can do it if you follow these other rules and that kind of thing. Brown's attested to his considerable experience used to develop his training session on diversity and cultural awareness. Brown has held a copyright for 2010 for his 54-page text on diversity awareness program. Nice. Brown attested the competitiveness of his educational programs, industry, and state. He developed a training program, unlike those used by the other school districts. Did he actually file at the Copyright Office? Did he actually file it at the Copyright Office and then say also it's a trade secret? That's exciting. That's exciting. I didn't know you can do that. Mostly because you can't. You can't do that. One or the other, man. One or the other. Yeah. However, by obtaining a copyright, Brown disclosed the materials in the application process. He actually filed for a copyright. But it's a secret, though. Well, all right. The Copyright Act is not a federal law that exempts disclosure under the relevant law. Right. There's a conflict between the Copyright Act and our law with respect to access, where public record in question is protected under copyright by a third party, and the local agency does not have the consent of the copywriter to duplicate the public record in response to the request. Well, Yeah, this reminds me of another example where this kind of happened with building codes. This happened, and I know some courts, at least I'm not sure every court, but I know some courts started whacking around the government for this, because it's like, okay, like the government the government can have a building code, and like, here's our building code, but some governments actually try to incorporate by reference private entities records or private entity standards. And they're like, okay, our building code is enforced by law. It can be found by the, Smith Agency manual. And it's like, we're not going to give you the Smith Agency manual because it's confidential or it's copyright and we can't reproduce it. And the courts that have kind of looked at that have been basically like, no, you can't do that. It's like, if you make it a law, right, you have access to the law, right? Fair notice. Like, this is the basic presumption behind, like, there's no, you can't use ignorance of the law as an excuse. Like, that's the fundamental presumption. Like, in theory, you could go look it up. I mean, it's all publicly known. So, like, you're on effective notice of all law because you can go look it up. You go to a library and you can read it. So, like, that's the presumption. And it's like, well, that's a bit of a problem if they can't go to the library and read it, right? It's like, okay, just pay this company money for the thing. And it's like, no, if it's the law, if I'm a builder and I'm building a house or building an apartment complex, you have to tell me what the law is so I can comply. It's like, you go pay them. No, you're the government. You're the one mandating it on me. So the courts that have looked at that have been like, no, you can't do that. Disclose the thing. Get wrecked. And then, of course, there was a somewhat famous case where Georgia tried to copyright its own statutes, which was hilarious. That was great. That was at the U.S. Supreme Court, too. The U.S. Supreme Court's like, we're not having that, too. Georgia tried to literally copyright its own code. Like, the code itself, the actual law is copyrighted. No, says the U.S. Supreme Court. You can't do that. No. So not so much. Keep trying, I guess. In any event, the Copyright Act limits access to a public record only with respect to duplication, not inspection. That's right. You can go read it. You can go to the Library of Congress and pull it and read it if you want. Thus, a copyrighted public record must still be available for inspection. Accordingly, any copyrighted material used by Brown and DEI staff must be made available to the requester for inspection. Give them the record. Regarding any non-copyright training materials, Brown's affidavit do not provide meaningful factual information. It cannot be ascertained whether the training materials are video, PowerPoint, outline, lesson plans, or something else. The affidavits do not explain how this information has value to the school district's competitor, the identity of the competitors, and likelihood of injury. In short, the affidavits are completely insufficient on their face. The school district's reliance on some other case is misplaced. In that case, the one with the student loan people is quite different from the school district. The student loan people was created by statute, but it's it's funded by its own operations, not appropriations from the legislature. So the debt collection people get money from the debts they collect, not from the general public. Furthermore, they took extraordinary steps to keep its manual on default confidential and shared only with a select number of employees. The holding does not support the school district, but rather instead the requester. In sum, the certification and supplemental attestation do not provide factually sufficient detail to establish the exemption for confidential and proprietary information applies to material. The affidavits do not even describe the training materials. For these reasons, we cannot affirm the conclusion. Accordingly, we vacate. And then they're going to have a hearing to decide whether confidential proprietary information exemption applies relative to this. But the Court of Appeals has already pretty much told you no. So they sent it back to the trial court for another go. Very exciting. So yes, the school district did not want to tell the parents, or for that matter, the general public, about the DEI. They're apparently ashamed by it, and they're trying to keep it secret using trade secret law, even though it's been disclosed to the Copyright Office and some other things. So yeah, that doesn't really work. You can't really do that. So no. But, thanks for trying and stuff. And technically, the trial court's supposed to have a hearing on whether the confidential exemption applies, but the Court of Appeals also already basically told you no. So, probably not. So I guess we'll see how that all persists. And that's a full pile of stupid. So are there any questions before I wrap up the stream? Just a quick rundown of any super chats that did come in, because there were, I think, 2 at least. Yeah, we read both super chats that came in, and we do appreciate their donation. Anything else before I wrap up the stream? All right, well, seeing nothing, I guess I'm going to go ahead and wrap up the stream. Just by the way, I probably am going to be offline for most of the next 10 days. I might stream a little bit. I'm, traveling, so I might travel. I might video some, but it's going to be more infrequent for the next 10 days. So I will see you at the end of that time, and we'll go from there. Until later, my friends, I've been Uncivil Law. I hope you have a great one. Cheers for now, my friends, and goodbye.